This is Matthew Reddish, the Regulatory Board Counsel for the Tennessee Athletic Commission. I'm going to read the statement of necessity for this meeting. According to Tennessee Code Annotated 8-44-108B2, the physical quorum is not present at the location of a meeting of a governing body. The governing body must file such determination of necessity, including the resuscitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, Tennessee Code Annotated 8-44-108A3 defines necessity as matters to be considered by the governing body at the meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is a regularly scheduled meeting of the Tennessee Athletic Commission. The purpose of today's meeting, with some members attending by teleconference, is to discuss the agenda as noticed on the website earlier.
Thank you. And since we've got one commission member present, I'm going to go ahead and do roll call. Mr. William Chad Chilcutt is not with us. Mr. Donald Wynn.
Present.
Thank you. Mr. Stephen Hanna.
Present.
And Ms. Tracy Miller-Davis.
Present.
Thank you. And today is Monday, December the 5th. Welcome, Ms. Miller-Davis. It is a pleasure to have you with us. The first thing I would like to note is that the agenda was properly noted on the website on November the 30th. We will need a motion and a second to accept the notice of the meeting.
Do we have a motion? Commission members, are you there?
Yes. I motion.
I second.
Mr. Wynn makes the motion and Ms. Miller-Davis seconds. Thank you very much. On the information emailed to you earlier, you received not only the agenda but the minutes from the last meeting. We will need to have a motion and a second to accept those.
Is there a motion on the floor to approve the minutes from the last session?
I second.
So moved.
On the statement of necessity that the attorney for the board, Matt, has read in, we've gone through it. The motion for the agenda, is everyone in favor? I'll need to do a roll call. Mr. Chilcutt is still not with us. Mr. Donald Wynn, are you in agreement with the notice?
I am.
Mr. Steve Hanna?
I am.
Ms. Tracy Miller-Davis?
I am.
Okay, and then with the minutes, the same thing. We motioned accepting the minutes without any changes. Mr. Chilcutt is not with us. Mr. Donald Wynn?
I agree.
Stephen Hanna?
I agree.
And Ms. Tracy Miller-Davis?
I agree.
Thank you. Okay. On our agenda, the next thing that we have is the director's report. That too was sent to everyone. The first item is it's called the Tennessee Athletic Commission Surplus and Deficit. The finance team has slightly changed the way that the financial information is presented. So we now on a monthly basis are able to see the expenses with a little bit of detail of all the cost backs instead of receiving them at the end of the year. So for the month through the month of October, we have a total of $22,525 in revenue and $30,158 in expenses. Again, the good thing about the expenses is that they do include quite a bit of the cost backs based on licensing and everything that's going on a monthly basis. So for the year, it does leave us in the whole $7,634. We're hoping that between November and December this can turn around a little bit. The bottom numbers are going to be reflecting some trends, and so as this new format is presented, I think the commission will be able to understand and see the picture a little bit better. We'll be able to compare each October to the previous year's October and so forth. So at the very bottom, you can see through the end of 2016, the $111,525 left over. And And then the following page that we have on our iPads that was also emailed is the year-end regulatory board expenses and revenues, and that particular document at the end of the 2015-2016 period shows $493 left, so pretty close when we finished. Mr. Chilcutt, were you able to join us?
Yes, ma'am, I'm here.
Fantastic. Welcome. Thank you very much. And we've done roll call, so I've added that you just came on board. We've gone over the statement of necessity, the agenda and the minutes, and the budget and director's report. Does anyone have any questions?
For those of you that are out, if you're outside, if you just want to put your phones on mute until you need to speak, that would be helpful. Thank you.
Thank you. Next on the presentation, we're going to look at the 2017 dates. Because this meeting has a small commission, it's really important that we're able to have quorum in order to conduct the meetings. We only need one person present, and the other two at least would need to be available by phone. So the dates that we've sent out are for March 13th of 2017, June 12th, September 4th, and December 5th. If those dates are a problem, if you could please let me know via email or phone in the event that we do need to change one of them. I don't know that I don't think we have to have all four, but I know that if there's a conflict with any of them, maybe we could address it early on. Any questions about those? I will need a motion to accept the dates for the 2017 session, please.
I'll make a motion to accept those dates. Is there a second?
Second.
It's Mr. Wynn.
I'll make a motion. Chad Chilcutt, I'm good for those dates.
And if you will, because we are on the teleconference, I will need to do roll call for them. If anyone is opposed, then let me know. Mr. Chilcutt, how are you voting?
Second motion that date.
Okay. Let me change my vote. Thank you. Donald Wynn?
I also agree. I'm good with those dates.
Thank you. Steve Hanna?
I'm in approval.
And Tracy Miller Davis?
I'm in approval.
Thank you. Okay, the next few items that we've got on the agenda are some items that I'll try to refresh so everyone is holding on to or looking at what was emailed as well. But before we proceed to the amateur sanctioning information, we would like to reiterate or rectify the decisions from the Bellator event that Commission Member Chad Chilcutt was able to participate in. Since we didn't meet in October, we didn't get a chance to cover this.
This is Matt Reddish, the board attorney. We were intending to get approval for Commissioner Chilcutt to appear at the Bellator event in Memphis to make any last-minute board decisions that needed to be made in case of any kind of emergencies that came up. Since we weren't able to get a quorum prior to the meeting, we had Commissioner Chilcutt appear, and so I want to go over a few decisions he made and now ask the board to vote to adopt or approve those decisions he made as the board's own. The only real issue that we had come up was in regards to the drug testing of one of the fighters. And when we had spoken with Bellator prior to the event, it was our understanding that this fighter in question would be drug tested by the Mohegan Sun tribe. Bellator contracted out with that company. And then when we got to the fight, it was our understanding that the fighter, his name was Shlemenko, would be tested prior and post-fight. However, only a pre-fight drug test occurred. And so after the fight, when our inspectors went to try to obtain a drug test from him, there was nobody there to collect any kind of sample. And in addition to that, the results had not been provided to the commission. And so myself, along with Commissioner Chilcutt, spoke with the director of the Mohegan Sun and made arrangements to have the pre-fight results sent to us, and if possible, to collect a sample from the MMA fighter in question as soon as possible. Unfortunately, he returned to Russia prior to being able to obtain an additional testing. And so that was kind of a decision that Commissioner Chilcutt made to just try to get the test as soon as possible afterwards and to have them send us the pre-fight results. We did receive those pre-fight results and showed that he passed all of his drug screening. And then also we used Commissioner Chilcutt as the Commission's representative to reach out to Bellator to inquire about paying their share of gate receipts and broadcast rights. And so he has reached out to Bellator from that position and worked with them to obtain those payments from Bellator. So I guess at this point I just wanted to ask for the Commission to adopt those actions as their own.
Before we do that, so is it the Mohegan Sun Tribe that was supposed to conduct the test after the fight?
It was a bit of a miscommunication on our end. We made our concerns known to Bellator because this fighter was just coming off a suspension for performance-enhancing drugs, and we let Bellator know that we wanted him tested. And since Bellator doesn't do their own testing, they contracted the Mohegan Sun. We were under the impression that it would follow, there's kind of a standard in the industry called USADA testing that involves pre- and post-fight. And I think we were going under the assumption that they were going to be following USADA protocols, when in reality what Mohegan Sun does is only a pre-fight test. So there's this confusion in regarding to what that drug testing was going to entail. And they agreed to basically make their best efforts to get that testing done, but the fight occurred around 10 p.m. on Saturday night. So there was nowhere open to get a test that night. We tried to get him to go to the hospital, but we couldn't find anybody to do the test then. And Sunday morning, he's on a flight back to Russia. So it kind of, our window to get a post-fight sample from him closed very quickly.
What was the outcome of that fight? Just curious.
He won by knockout in the second round, I believe. Do you remember Commissioner Chilcutt?
Yes, that's correct.
I believe he won on a blow to the opponent's solar plexus and knocked him out. And his opponent didn't raise any, that we know of, I don't believe he contested the results or raised any kind of issue.
So we just need to vote on accepting a motion to approve the actions that were taken at the fight?
That's correct. And if you want to try to do anything further than that, I mean, if you want to request a complaint be opened or something like that, we can do that. But at this point, we just want to say that, the Commission agrees that it was the Commission's stance that they should try to provide that test as soon as possible afterwards, more or less.
Oh, I mean, we had the pre-fight test, and then nobody was contesting anything, so.
That's correct.
So I'll make the motion to approve the actions that were taken relative to this matter. Is there a second?
I second.
Mr. Nguyen?
I'll do a quick roll call. We've motioned to approve the actions as taken on the Bellator fight by Commissioner Will Chilcutt. And so, Mr. Chilcutt, are you in agreement with the motion?
Yes.
Mr. Donald Nguyen?
Yes.
Mr. Steve Hanna?
Yes.
Ms. Tracy Miller-Davis?
Yes.
All in agreement. Thank you. Okay. Next, we wanted to discuss, and we've had different questions regarding posting of sanctioning bodies to our website. We've got, and I include in the email, an item that's been available out there for the sanctioning amateur organizations. We can leave that out. It starts with Tennessee Athletic Commission approves for amateur sanctioning organizations. I think, and I'll let Matt again kind of take over and continue, but as we get called and asked to list these organizations or who we send the amateur information to, it would be okay if the commission agrees to have these on our website, those that are approved, and if the commission's okay with it, as others come up that are recognized and that we could properly vet, the commission can give the board office or myself directly permission to add these to the list. It would give people a place to go to see these.
Makes sense. Yeah.
Does the board want to try to offer any kind of criteria that they want the executive director to look for in improving these? Or possibly we could appoint somebody from the commission to consult for her to consult with on this or anything along those lines, or do you just want to completely leave it to her discretion?
Well, I'm fine. In the past, I think they've had to approach the commission and present, who there are. Changed at all?
We can continue doing that. We just haven't lately, so.
Sure, we're not really sure the process the previous commission followed, so you might be a better resource on that. If that's how it previously was, I think that's a suitable way going forward.
Be with that?
That would work
Be
fine
fine
for
with
us,
you?
absolutely,
I
as
mean,
long
I
as,
guess my only concern would be that
wait.
sometimes, it's a 30-day application period. We meet every quarter, so it could be situations where we can't get in front of you in time to have a sanctioning body approved.
Any idea how many have approached us for approval in the past 6 months?
I'm staring at Aisha. She's got more of the feel for 3, 4.
Waco just recently did a submission to do amateur kickboxing here, and eventually they want to present pro sanctioning here as well.
So their presentation is on here for you to review. So when it's pretty close to us having a meeting, I think that makes perfect sense to present
So
to
let
the
everybody
commission.
weigh in? Yeah,
Yeah,
I'm fine with
to
that.
get everybody to look at it. It would just be that situation if they've just missed a meeting, they'd have to wait an entire quarter.
I think normally the 4 that we approved previously are 4 of the more active ones. I know like IASKA or ISKA, I can't remember the acronym now. They do a lot of the MMA. We have USA Boxing, World Karate Association, International Kickboxing Federation. I think those are the biggest sanctioning bodies anyway. So maybe what we can do is if you just want to have, Roxana can make the judgment call, and then we can present them at the quarterly meeting, and we can maybe retroactively ask you to approve them going forward and add them to the website, something along those lines.
I'd be in favor of that. That's fine.
Me too. I'm in favor of that.
I agree as well.
I agree as well.
I think we've had all 4 voice their agreement in doing a motion to where the office would review the criteria and go ahead and approve them. If the board meeting or the commission meeting is a ways away, then we would bring it back to the commission to review, and we would be adding these names to a list that we will maintain on the website of all these approving entities. Thank you. You have before you on the documents and on the iPad, we are on page 10, a letter from, as Aisha mentioned, Waco is wanting us to review the information, their rules and documentation of what their body does. And so we've presented it for you. The letter is kind of a quick recap of their styles, the KI, low kick, and full contact for ours to approve. I'll give everyone a minute if you haven't had a chance to look at it. The letter's from Mr. Rob Zabilski. I believe he was going to have someone else representing him that was going to want to speak. Are you Kevin? Kevin, nice to meet you. Okay, so if there's any questions, he was not able to come before the board and said that Kevin could answer some of our questions.
Come to the mic, sir.
If, as you speak, if you down on that.
Sure.
Thank you.
So if you'll just let us know again for the record, your name and the name of your organization, if you would, I'd just like the opportunity to get to know more about you and your organization. Tell us kind of how long y'all been in business and whatnot.
Yes, my name is Kevin Walker, and I'm representing WACO, which is an acronym for the World Association of Kickboxing Organizations. Our mission uh, is to push for the approval of kickboxing into the Olympics. We are the governing body in this country for that particular sport and discipline, and that's what we're here to do. We're looking to have more Americans in international competition, which is lacking, and as such, with more participation from this country, we can push the envelope for having acceptance into the Olympic Games.
How many other states are you approved for?
Currently, there was a bit of a modification in the representative here in the United States. Actually, this rule set was approved about 2 years ago under the organization which is known as Kick International and UMAF, United States Mixed Martial Arts Federation. However, they are no longer the representative body for kickboxing and just for mixed martial arts at this particular point. So it's the same rule set, same world organization. However, the country representative body has changed.
Are there any questions from any of the other commission members? Mr. Chilcutt or anybody else?
This is Don Wynn. I think I'm good.
I don't have any questions. Chad Chilcutt.
Tracy, I have no questions.
So we would want to, are we in a position?
Is there a motion to approve WACO as a sanctioning body?
I'll make the motion, Steve Hanna. Is there a second?
I second Don Wynn.
Third, Chad Chilcutt.
Ms. Tracy, are you in agreement with the motion?
Yes, I didn't think you heard me. I approve.
Okay, so we've got a unanimous motion to approve to include WACO as sanctioning body. Thank you. Next, thank you very much. We have also on information that was emailed and on your iPads, we are on page 41. This is regarding the boxers' weight classifications. Again, something that came up, I think, before the last meeting for the board to take a look at and see if this needed to be added or changed.
We've had some people reach out to us and have pointed out that our weight classifications don't match those that the Association of Boxing Commission abides by. I'm not really sure how much of any kind of competitive disadvantage this would put us into. Maybe some of our boxing people probably know better than I. It looks like really the next page lists all of ABC's weight classifications. It looks like a lot of ours match up, but they have several additional weight classes that we don't currently classify people in. And that if we wanted to change this, I think we would need a request to legal for a proposed rule at the next meeting. And I think if you looked at today's rulemaking, we could probably come up with a rule similar to how I've addressed our list of MMA fouls. Just make it something that changes as the Association of Boxing Commission alters its weight classes.
It would be my preference to have, I mean, it's fine the way it is, but I would certainly want to be able to accommodate someone such as the UFC to make sure that we're consistent with act on our year, whether or not it's a good year or not. Fantastic.
Sure. We're actually going to we're going to get into rulemaking later on. So if at that point someone wants to just make the request to legal to draft some rules for your review at the March 13th meeting. I'm happy to have some rules ready for everybody to look at. All right, so we have a legal report, only has 2 cases on it. Has everybody had an opportunity to read this legal report prior to the meeting? There's, like I said, 2 cases, 2016-03-2581 and 2016-045931. Does anybody have any questions for legal regarding my summary, need additional facts, or have questions regarding my recommendation?
Any questions from the commission? For Mr. Reddish?
This is Don Wynn, no question.
I don't have it in front of me right now. Could you briefly read it to us again, Matt?
Sure. I'd be happy to. Case number 2016-03-2581. Complaint alleges complainant was knocked out by an illegal blow and therefore fight should be declared a no contest. The alleged illegal blow was a punch to the back of the head while the complainant was on the mat. Review of video shows that complainant was mounted by the opponent when he was struck in the back of the head by one punch. The blow landed to the back of the complainant's head because complainant tucked his head to avoid being punched in the side of the head. There's no evidence that the other combatant intentionally committed a foul or that any clear foul occurred that should have caused the referee to intervene. During the bout, the referee did not call a foul. My recommendation on that case is to close the complaint. Does anybody have a question on that particular case?
No, thank you.
All right, case, sorry, what was that?
Oh, I was just saying no questions for me.
Okay. Case 2016-04-5931. Complaint submitted by a promoter alleging respondent breached his contract without just cause, resulting in the promoter suffering financial loss. Investigation was conducted by our department. According to the respondent, he withdrew approximately 1 month before the fight following an argument he had with the promoter regarding how the promoter treated an amateur fighter, that is the respondent's student. The complainant informed investigator that he wished to withdraw his complaint. My recommendation is to close.
Any questions for Mr. Reddish on these 2 complaints?
No questions, sir. Chad Chilcutt.
Is there a motion to adopt the legal report?
I'll make that motion.
I second it.
I third it.
This is Tracy, I approve.
Thank you. Approved by all.
All right, the next matter I want to talk about was rulemaking. We briefly discussed this at our last meeting. We couldn't make any kind of decision, however, because we didn't have a quorum. If you recall, there at the Association of Boxing Commission meeting in August in Las Vegas that I attended, there were changes to the ABC's unified rules for MMA fouls. I believe in the packet it looks like we have the boxing rules, but this will actually cover the MMA rules. And what it did was it altered the definition of a grounded opponent. It allows for the grabbing of clavicles. It also allowed for heel strikes to a combatant's kidney. I believe those were the foul changes that the ABC promulgated and approved. And so, and additionally, they also came up with new rules for how to score an MMA round. I know John McCarthy and several others were instrumental in coming up with these new rules for scoring rounds, how we want to do a 10-10, a 10-9, a 10-8, and a 10-7. What the outcome of these rules really is that, as other states adopt these, we want to make sure that we're in conformity with, for example, Nevada and California and these other states, because, for example, UFC is going to want to go to states where they can keep their fouls and scoring standard. They don't want to have to try to retrain the referee. I know in Tennessee this is a foul, and go to another state and this is a foul. So the idea is we want to have unified rules. And so I put together a rule proposal. Has everybody had a chance to read through these prior to the meeting? I'm happy to read them, but we'll see if anybody had any questions ahead of time.
I did get a chance, and I don't have any questions.
Okay, so what I've basically done is I took everything that used to be a foul in kickboxing, and I've kept it a specific foul for kickboxing. You'll see that on paragraph 2, where basically I deleted out all of, this is on rule 0145-03-04. And so I amended this rule by deleting the fouls outlined in paragraph 2, and I have moved those fouls to paragraph 1, so that now, in addition to the fouls currently in paragraph 1, it will include JJ arm bars, paragraph KK grabbing or holding onto an opponent's leg or foot and grabbing or holding onto any part of the body, paragraph LL punching or kicking a combatant when the combatant is down. A combatant is down when any part of the combatant's body other than the combatant's feet touch the floor. A combatant's opponent may continue to attack until his combatant has touched the floor with any part of his body other than the feet. Subparagraph MM, leg checking, which occurs when a combatant extends the leg to check an opponent's leg or to prevent the opponent from kicking. Paragraph NN, purposely going down without being hit. Paragraph OO, any use of throws or any takedowns. Paragraph PP, holding and hitting. Paragraph QQ, hitting or slapping with an open glove. And paragraph RR, using the heel of the palm of the hand to deliver a blow to the face. So all of these were previously kickboxing fouls, and they will stay kickboxing fouls. The change really occurs in subparagraph 2, which as amended will state, for the purposes of mixed martial arts tactics fouls, the definition of fouls and the definition of tactics shall be as approved by the Association of Boxing Commission Unified Rules of MMA. These tactics are fouls and shall result in a warning and loss of points as determined by the referee. Actually, that last paragraph should be deleted. So it should just say, for purpose of mixed martial arts, tactics, fouls, the definition of fouls, and the definition of tactics shall be as provided in the Association of Boxing Commission, ABC, Unified Rules of MMA. And then one additional change I also made, this is Rule 0145-03-.10. Scoring is amended by deleting the rule in its entirety and substituting instead the following language, so that as amended the rule shall read. And then I created a new subparagraph 1 which will read, during mixed martial arts contests, referees and judges shall use the Association of Boxing Commission's MMA judging criteria scoring guidelines when scoring contests. And if you see on subparagraph 2, I changed that so that our current standard that is applied to kickboxing will continue to be applied to kickboxing, so there should be no change there. And so what this should do is align our rules exactly with those promulgated by the Association of Boxing Commission. I believe 46 states are members of the Association of Boxing Commission, so it should bring a lot of uniformity to our rules. And then a third rule change is Rule 0145-03-.15, gloves, and this is our definition of gloves. And so I've added in here that all gloves shall have padding over the knuckles. It was brought to our attention that technically our rule doesn't require that our gloves have padding over the knuckles, which could lead to some people have made inquiries into bare knuckle boxing, things along those lines. And so if the commission feels that that's something we want to try to prevent, I think this rule would be a good way to not allow bare knuckle boxing to get a foothold here. So we have three different rule proposals. We can go through one by one, and the commission will need to roll call vote whether or not to approve each of these or not.
And for the,
And
just to make
we can take public comment also if anybody wants to comment on any of these rules.
and so that we can just make sure that we're all on the same page with the iPads. When we go through these votes, can we just reference that?
Sure, we can just say, Rule 0145-03-.04. We can do a roll call on that. sorry. And then afterwards, I'll have some additional language I'll need to read and we'll have to approve.
Before we do that, are there any comments from the commission, or are there any questions from anyone here in attendance?
No questions for me.
Okay, so is there a motion to approve? Can I just call it rule number 1? Or would you like to state it for the record, Matt?
Amendment to Rule 0145-03-.04.
I'll make a motion to approve. Is there a second?
I second it, Chad Chilcutt.
Well, I agree, Donald Wynn.
I agree, Tracy Miller Davis.
Thank you. By roll, we have everyone in agreement for the first change in the rules, which is 0145-03-.04. Thank you. All in agreement.
All right, second rule is Rule 0145-03-.10.
I'll make a motion to approve. Is there a second?
I second it, Chad Chilcutt.
I agree, Donald Wynn.
I agree, Tracy Miller Davis.
Thank you. All four in agreement.
And then the last rule amendment is Rule 0145-03-.15.
I'll make a motion to approve. Is there a second?
I second it, Chad Chilcutt.
I
I
agree,
agree, Donald Wynn.
Tracy Miller Davis.
Thank you. All four in agreement.
Okay. I will need to read some statements. After each statement, we'll need a motion to adopt and then another roll call vote. The first thing I need to read is the regulatory flexibility addendum. So if you'll bear with me, this will take a little while. Pursuant to Tennessee Code annotated sections 4-5-401 through 4-5-404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rules affect small business. Question 1. The type or types of small businesses and identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. Answer. These rules will only affect mixed martial arts events and contests. There were approximately 16 mixed martial arts events that the Tennessee Athletic Commission issued permits for in 2016. The promoters, referees, combatants, and judges for these events and contests will benefit from these rule changes because it will eliminate confusion that these parties have when working across state lines. The requirement that gloves have padding over the knuckle will eliminate a potential loophole in the rules that could conceivably permit bare knuckle boxing or other glove designs that would place combatants at greater risk of physical injury. Compliance with these rules is not expected to have any additional costs. Question 2. The projected reporting, record keeping, and other administrative costs required for compliance with the proposed rules, including the type of professional skills necessary for preparation of the report or record. Answer. There are no expected reporting, record keeping, or other administrative costs expected in order to remain in compliance with these rules. Question 3. A statement of the probable effect on impacted small businesses and consumers. Answer. The promoters operating in Tennessee often hold contests and events in neighboring states. The judges and referees for mixed martial arts events and contests are specially trained and must often be flown in from other parts of the country, meaning they can sometimes be unfamiliar with the particulars of the Tennessee Athletic Commission's rules and laws. The probable effect of these rules is positive in that all parties will be familiar with our rules, thereby reducing confusion and the potential for rule violations. Additionally, if Tennessee allows its rules to become materially different from those promulgated by the Association of Boxing Commissions, then the state will place itself at a disadvantage when trying to attract larger events and contests. Question 4. A description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small businesses. Answer. The Commission believes these changes are not burdensome, intrusive, or costly, and, as such, there do not appear to be any alternatives that would reasonably be expected to be less burdensome. Question 5. a comparison of the proposed rule with any federal or state counterparts. The Tennessee Athletic Commission is directed by Tennessee Code Annotated Section 68-115-501 to be a member of the Association of Boxing Commissions. The statute requires that the Tennessee Athletic Commission use ABC's Unified Mixed Martial Arts Rules as a regulatory guideline for the promulgation of mixed martial arts rules. Most other states have also adopted ABC's Unified Rules for mixed martial arts purposes, and as such, these rules are comparable to the rules of those states. Question 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rules. Answer, exemption from these rules would not be expected to be beneficial for small businesses because these rules should have a net positive benefit for all Tennessee Athletic Commission licensees in the state. So at this time, we'll need a motion to adopt this regulatory flexibility addendum.
I'll make the motion.
I second it.
I will third it.
DeWin was a second. Mr. Chilcutt's in agreement. Is there a,
Ms. Tracy, are you there?
Yes,
Are you- Are you also in agreement?
yes, I am in agreement.
Okay, all four in agreement. Thank you.
Next statement is the impact on local governments. Pursuant to Tennessee Code Annotated Sections 4-5-220 and 4-5-228, any rule proposed to be promulgated shall state in a simple declarative sentence, without additional comments on the merits of the policy of the rules or regulation, whether the rule or regulation may have a projected impact on local governments. Answer, this rule will not have a projected impact on local governments. So we'll need a motion to adopt this impact on local government statement.
I'll make the motion.
I'll second the motion.
Chilcutt, are you in agreement?
I'm in agreement, Chad Chilcutt.
And I'm in agreement, Donald Wynn.
Thank you. All four in agreement.
All right, the last thing I need to read, regulatory flexibility analysis, methods of reducing impact of rules of small businesses. Each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. The agencies shall consider, but not be limited to, each of the following methods of reducing the impact of the proposed rule on small businesses while remaining consistent with health, safety, and well-being. Question 1. The extent the rule may overlap, duplicate, or conflict with any federal, state, or local governmental rules. Answer. There will be no overlap, duplication, or conflict with other federal, state, or local governmental rules. Question 2. Clarity, conciseness, and lack of ambiguity in the rule. Answer. The rules are clear in purpose and intended execution. The implementation of the proposed rule change will reduce ambiguity in the rules for gloves by eliminating a loophole through which bare-knuckle boxing could arguably have been performed. The rules will also make Tennessee more competitive in attracting mixed martial arts events by bringing our rules into uniformity with the majority of other states across the United States. Question 3, the establishment of flexible compliance and reporting requirements for small businesses. Answer, these rules do not create any new compliance or reporting requirements. Question 4, the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. Answer, these rules do not create any new compliance or reporting deadlines. Question 5, the consolidation or simplification of compliance or reporting requirements for small businesses. Answer, there are no new compliance and reporting requirements. Question 6, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. Answer, these rules do create some operation design standards for mixed martial arts due to reclassifying how bouts are scored, what constitutes a foul, and what gloves must be worn. However, they will be for the benefit of small businesses by allowing the business to attract more wealthy and established promotional partners, and for the benefit of fighters by removing potentially dangerous glove designs. Question 7, the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. The rule on glove padding will create a barrier to entry for those wishing to organize bare-knuckle boxing events and contests in the state of Tennessee. However, these events would already be unlikely to gain commission approval. It does not appear that these rules will erect barriers or have other effects which would stifle entrepreneurial activity, curb innovation, or increase costs. In fact, these rules lower costs by creating uniformity across multiple states, which will hopefully encourage growth. That concludes our methods of reducing impact of rules on small businesses.
All right, thank you, Mr. Reddish. Is that anything else on in the legal reports?
And did you want to formally request that I draft rules regarding boxer weight classifications?
Yes.
All right.
Is that going to take a vote or just a request?
We can vote on it.
All right, so the motion on the floor, which I will make, is just to have Mr. Reddish to create some language that would give us some flexibility around the weight classes.
For boxers?
For the boxers. I'll make that motion. Is there a second?
I will second it. Chad Chilcott.
I agree, Donald Wynn.
I agree, Tracy Miller Davis.
Thank you all for an agreement. Okay, the last item on our agenda would be new business.
Go over the point system
No.
for approving boxers. One moment. Okay, one thing that I believe we've had some discussions about is in regards to boxing bouts that are being set up that aren't competitive. Currently, we just basically approve any bout that the boxing promoters bring to us because we haven't really had a chance to discuss this with the commission yet. However, I wanted to make a proposal. This is on page 49 of your iPad. And so I'll just go ahead and read this memo for those who don't have it in front of them. So it's titled Internal Procedure for Review of Proposed Contests. This policy is intended for the use and guidance of the staff of the Tennessee Athletic Commission. This document is not intended to create any substantive or procedural rights enforceable by any party in the administrative and judicial litigation with the state of Tennessee. Tennessee Athletic Commission reserves the right to act at variance with these guidelines. Tennessee Comprehensive Rules and Regulations 0145-01-.04 subsection 4 provides if the Commission's administrator determines on the basis of available information that proposed contests would not be reasonable and fairly competitive, the administrator shall so advise the promoter within 5 business days after receipt of the application submitted in accordance with this rule, unless the administrator is offered evidence or argument which causes him or her to reverse that determination. Such contest shall not be held in the state, and any permit issued for a program of multiple unarmed combat contests shall not include the same. The applicant may appeal the administrator's decision to the commission. In determining whether, that's the end of the rule, back to the memo, in determining whether or not a proposed contest would be reasonably and fairly competitive, in addition to any other information that the administrator may reasonably consider, the administrator may use the following system to assign points to each combatant in a contest and may consider factors including large score differentials between fighters as well as high individual scores in determining whether or not to allow a fight to proceed. As provided in the rule above, an applicant may appeal the administrator's decision to the commission, and the administrator maintains the authority to determine whether a proposed contest is reasonably and fairly competitive, notwithstanding the score of any fighter or the differential between two fighters if, in the administrator's discretion, the administrator decides that the fight is otherwise reasonably and fairly competitive based on the individual's facts and circumstances of the contest. Under the system, points are assigned as follows. Criteria number 1 for assigning points is activity. If the fighter has 0 or 1 fights in the last 2 years, then they receive 1 point. If the fighter has fought more than once in the last 2 years, they receive 0 points. Criteria 2, recent record. If the fighter has lost 5 in a row, they receive 2 points. If the fighter has lost 3 of the last 4, they receive 1 point. If the fighter has won 3 of the last 4, they receive -1 point. Criteria 3 is knockout or technical knockout. If the fighter has been knocked out or technically knocked out more than 4 times in the last 2 years, they receive 3 points. If the fighter has been knocked out or technically knocked out between 1 and 3 times in the last 2 years, they receive 2 points. If the fighter was knocked out or technically knocked out in their last fight, they will receive 1 point. Criteria 4 is age. If the fighter is over 44, they receive 3 points. If the fighter is over 35, they receive 2 points. Criteria 4 is ring age. If the fighter has over 500 rounds in their professional career, they receive 1 point. If the fighter has been a professional for more than 5 years, they receive 1 point. So we would ask the commission to adopt this policy. This is some background on this policy. This is a system that California uses to judge whether or not a boxing match is going to be competitive or not. This is something that was, they gave a presentation on at the ABC meeting in August. And I know that we've had a lot of scenarios come up. I know James is here. Maybe he can speak on this some, but we have a lot of fights that we look at, and it seems kind of obvious that these aren't going to be competitive. We have where one boxer's 33-2, and another guy has lost his last 16 bouts, and he goes in and gets knocked out in the first round, somewhat predictably. And so what this would do is allow us to assign points to the fighters and identify what fighter basically has no business being a professional boxer in the state. If somebody does have 5 or 6 points assigned to them, they need to be fighting somebody who also has 5 or 6 points. They don't need to be lined up against somebody who has 1 or 2 points.
It seems like a reasonable approach to that problem. Who's going to be the person that's policing this, I guess?
James, you want to come up and maybe talk? Because James and I have actually plugged some fighters into this formula before to see, just try to figure out how many of our fights are to this level. James, can you maybe discuss, the ease or difficulty you felt in trying to put these in,
and how accessible is the information? Like, you got a fighter coming in from out of town. How easy is it to find out past results? You know what I'm saying?
First of all, my name is James Oldie. Basically, it took out the ambiguity of matching. It was rather quickly. It didn't take a lot of time. What we found was that in using the point system, that a lot of matches were terribly matched. It almost appeared to be padding for some fighters. So our concern most certainly would be the competitive nature and the safety of the fighters. There's some fighters that really were matched poorly with their opponent and could have been a security issue. So it's fairly quick and simple once you understand the point system.
Again, it seems very reasonable. I'm just trying to...
sort of other part of the question, I think most of the information is publicly available through reporting services that we subscribe to. And one thing I forgot to point out, just as a point to show how effective it was, the California Athletic Commissioner, Athletic Director, obviously California is one of the 2 or 3 biggest boxing states in the U.S., so they've used this process repeatedly. He said no fighter who had a score of 5 or above has never won a single round of boxing. He's only approved a few fighters that were a 5 or 6 or 7. They've never won a single round of a bout. So just to give you an idea, anybody who's ranking as a 5, how uncompetitive they are. So.
Gotcha. Thank you, Mr. Oldie. So what's on the floor right now is whether or not we proceed with the internal procedure for review of the proposed contest. I'll make a motion to approve. Is there a second?
I will second it, Chad Chilcutt.
I agree, Donald Wynn.
I agree, Tracy Miller Davis.
Thank you. We have all 4 in agreement to proceed with the process of this criteria for the point system, and we will definitely make sure to review and get something ready, and at the March meeting, the next meeting of this commission, we'll be able to give you some updates on it as well. So we've got everybody agreeing to proceed.
We'll get a copy of this printed. We'll need you to sign it, Chairman Hanna.
Okay.
I've got one other item that we put under new business. The office, in conjunction with investigations, as James just spoke to you all, has seen an increase on last-minute applicants for participants, be it the seconds, anyone that falls in that category. And so we're trying to hopefully go about this through education more than anything else for those events that are going to take place, and welcome any thoughts and ideas that the rest of the commission has, so that we don't have to put something in rules necessarily that doesn't have to be overregulated. What we've seen an increase in is those events that have 4, 5, 6 different fights, if you will, and the participants are 2 to 3 for each one, but they're waiting till the last minute, till the day of, to get their license. And so you've got seconds going up into the field the inspectors that are ready to focus on the event and that are ready to concentrate and make sure that everything is proceeding and do that part of business. And here they're having to actually license individuals. So we would love to see a shift and welcome any ideas so that we educate better, we get the information out that 7 days prior to the event, those participants also need to be licensed. What happens at the day of the event is they're taking applications, they're taking money, and at the last minute, instead of focusing on the important piece, they're having to deal with licensing, which we hate for it to be that part. The increase lately may just be a coincidence, but a thought that, as we debated, was to obviously educate, and when we are starting to talk about the event itself, at that point, fill everyone in on, and we do that, and Aisha does an amazing job, and Iman is now training in the office, so that hopefully we'll have staff cross-trained to be able to all do this, but 30 days prior to the event, we want to make sure that we've got that event permit out and that they're understanding who needs to get licensed and how. But 7 days before the actual event is when we would like everything to be finalized. That way, the team that is going out and the field people that are going to be there know exactly what's taking place, and there's no loose ends. On rare occasions, we can see making an exception and letting someone substitute, and we hope that those will be few and far between. But we want to really focus on communicating so that our seconds and all the participants are done as far in advance as possible. So a thought that we had is maybe to improve the communication when the event permit goes out, kick out a letter, whether we actually put it in the mail or email it. It would be a letter with the next step of instructions, if you will, that would say, congratulations, your permit's been mailed. Here's the next step. Please remember these dates. 7 days in advance, we will be finished. And then encouraging, whether they have 1 or 2 or 3 seconds, to make sure that everyone is licensed far in advance. And then any other recommendations that the commission has, we're thrilled to do, just so that it can be a communication piece instead of needing to be in the rules.
It's a great idea, as long as, if you could just include like a roadmap, like you've referenced, and a high-level one. We don't have to get into too much incredible detail, but just, like maybe 4 or 5 bullets that says, here's, 30 days out, here's what you should do, or what should have been covered. So I think it's a great idea. And maybe something on the website as well.
Yes, yes, and we've got things on the website, but as you know, sometimes it's a lot of reading.
Right.
We're finding that the shorter and the simpler it is, the better. So we will definitely pinpoint some of these things. I think that's what we're going to test first, is to see when that permit goes out. It's going to be a simple, to-the-point bullets of what to do here in the next few weeks. And we're going to attempt email first, because we tend to do good communication through email. And then, if all else fails, we'll move to mailing the letter. So I wanted to make sure that everyone on the commission heard. Are there any other concerns or ideas on what else we can do? Open up to the other members.
This is Chad Chilcutt. I have a question regarding once the permit's approved 30 days out, and then the fighters are still coming in. You still have issues with last minute, trying to get everything approved and get it from the fighters. We run into that problem so much. So I thought of something for the board to look at, as far as maybe adding some type of late fee, to the ones who are not on their game for whatever reason of getting it in. It's not always the promoter of promotions fault. They're working hard to try to get it done, and sometimes you're dealing with fighters and they drag their feet, and then the other fight, to make the fight happen, then one fighter doesn't do everything right, and they wait to the last minute, and we're still trying to make the fight happen. So we run into that with Bellator, but not only Bellator, but it's a lot of promotions we run into that.
And I thank you for your comment. We, of course, Aisha can probably be the first to test, but I agree. We want the 30 days out to have that permit and the road really well envisioned, so that we know how many fights, and start working on the blood work and responding and letting them know what's missing and who's expired. But inevitably, almost every fight runs up to the last minute, and with exceptions. I don't know about a penalty. That would have to be a rule change for us to actually be able to charge someone for being behind and late. Our penalty's there if you don't renew on time, but I think for that initial license, we really, without a rule change, couldn't impose something like that. The hard stance is, of course, then saying you didn't get it done on time, we can't make the change. On occasions, we've said that, we've tried to be as understanding, and that's always our first approach. But it does make it tough, I'll be honest. It makes it tough to get it done when there's other boards to play. But I think if we get some of these bullets out in advance, hopefully that will help as well.
And also, on the event permits, they have the option to choose alternatives. So if somebody does drop from the ballot, they can bring somebody else in. So they have that option.
What's the time span to bring somebody else in?
Everything has to be licensed at least within 7 days from the bout. So no changes after that. But if they have alternates up before then, they can focus on getting blood work. So even if the promoter doesn't use them for that fight, they can use them moving forward.
It sounds like having those alternates when you do the permit is a good educational piece that we could push as well. There's nothing wrong with having them, and if you don't need them, then that's perfectly good. But then substituting at the last minute would not take as long.
Have we checked with, in the spirit of not trying to recreate the wheel, have we checked with like Nevada or California departments of
Time frame?
just what they do in these situations?
I think usually the industry standard is to let people get licensed, the day before the fight. A lot of states I know allow that. The problem being, just kind of an economies of scale idea that Nevada and California, as other states, sometimes have a lot more resources than we have to work with, just because they have so many more fights. That's why, if you saw on the director's report, we were able to actually get into the positive this year, as opposed to so many of the previous years being in the red. One of the things that allows us to do that is that we're able to bring people into a system where we're able to process them more efficiently. So I know that some of the fights I went to before we started trying to push people to get licensed 7 days out, it was very hectic, because we're trying to do a weigh-in, we're trying to get people over to the medical examiner. We have our inspector out there collecting fees in cash, which is obviously always a concern. I do know that we do have the capability now where people can apply online and pay with a credit card online. So, I mean, I do think that there might be a situation. I mean, first of all, I want to say, not first of all, but at this point, I guess I just want to bring up that we always have the flexibility, similar to what we do with Bellator. The commission has the flexibility to allow somebody to be within the 7 days if it's different circumstances, which is what we kind of do with Bellator. You know, last minute, turned out they had a bunch of fighters that hadn't gotten licensed yet. We said, hey, license them today online, pay with a credit card, and it kind of worked out for them. Trying to go that route, maybe if when we run into these situations where people are having problems making the deadline. I believe it's really our small promoters that are repeat promoters in the state. They seem to have liked the system. I've talked to them some. You know, they like being able to do it all online and having it in ahead of time. But it's because they're familiar with how we operate, as opposed to when someone like Bellator is coming through who doesn't operate the same, other states don't necessarily operate like ours. They weren't prepared, and they didn't have a system in place to have the organization necessary to get it all in on time. I guess that's just kind of like my 2 cents on the situation, that it's easier to make an exception for somebody as opposed to having to be the industry standard where they're getting licensed last second.
You hit a very important topic, which is efficiency and making sure that we operate in the most lean way possible. So we'll continue down. I think, just based on what I'm hearing, I would certainly be in favor of just that educational effort and just see how that goes before we make any major changes. I think the idea about a fine is great because that's a great motivator, but we could accomplish this just through the education piece. So.
That sounds great, and we always want to encourage, because I know that the industry as a whole always reaches out to the commission members and always point them in our direction, and if we keep sight of that, the 30 days allows us to see that big picture of the event. We are also, come January, going to add a calendar to the website that's going to be where they can see all future fights. It'll have some, anybody that's kind of put out a tentative date for a June fight or July. That way they can start looking and hopefully plan out far enough that they see where the gaps, we're going to put what part of the state it's in, and then they'll be able to pick dates. It's just an additional tool for those, especially the smaller fights maybe that are coming in and wanting to see where am I going to get, really a good spot where nothing's taken and I'll be able to get some fighters. So we're going to put that calendar out there, additional educational pieces. But as Matt said, just getting our people that are there the day of the fight to concentrate on the important piece instead of collecting licenses and money would be fantastic, I think, for everyone. So we will keep pushing all these things, and I welcome ideas anytime that you've got something that you think will work or someone's reached out to you that on a way we can improve. We always welcome that. Thank you.
Seconds, or is this on everybody?
Participants in seconds, your seconds that are up.
That conclude the legal report?
Legal and
new
everything that
business?
I've got is
Yeah.
new business. Aisha, did I miss anything that you can think of? No? Okay.
So I'll open it up at this point. If there's any new business from either commission members or visitors that we have here today, which is quite a few, thank you for coming. I hear none, so I'll certainly take a motion to adjourn. I'll make that motion. Is there a second?
Second.
So moved.
Thank you very much. This
Thank you.
concludes the meeting.